All right, we're live.
All right, we're back in Senate Judiciary. Switching gears, Representative Malone has come down to visit and to give us a primer on H2. The reason we're doing this for crossover is because we're on a bit more of a tight timeline for this particular issue. So, the floor is yours.
All right, Mark Malone, representative from South Burlington, chair of the House Judiciary Committee. So H2 is the culmination of our work on juvenile justice, including these age issues. The first part of H2, which has not been controversial, is raising the age for the lower limit of who goes into delinquency into juvenile court and family court, raising it from 10 to 12. This was initially from a recommendation from RDAP, which I'm not going to be able to say what RDAP stands for. Racial disparities in juvenile justice is but it's been well received as far as with raising that age and certainly into the details of that. So we started out, we had several days of testimony, first on just juvenile justice in general, and then on raise the age. And we initially tried to do a bill that would address quite a few issues, including the so-called ping pong effect, where case can be in family court, then jumps up to criminal court, then goes back to family court. We tried a couple approaches to potentially resolve that. We'll find that that's not in this bill. Actually, I'm going to tell you what's not in this bill first. We also understood as far as issues or concerns related to accountability, particularly for 18-year-olds and potentially 19-year-olds when we mentioned to raise the age. And so we did some work on trying to address that as well. We had a couple different approaches that we tried. Again, could not get people to coalesce around a solution to that. So both of those issues, if you recall, last year we established a task force. I think it was a S58, if I remember right. Maybe in one of the other bills in the Senate. That set up a task force and come back to us about really the transfers that occur in family and criminal courts. I think initially the idea of everything starting from family court and then different paths to the criminal court. And I think they're going to be dealing with the so-called ping pong effect there. And I'd like to ask them to further look at this accountability issue as well. So those things we've tried, but this thing keeps on getting narrowed down. So what it does now, one of the main things it does is it does delay raise the age, which would go to 19 years on April 1st, unless something is passed. So we heard a lot of testimony on this, and we had certainly we had one individual, the child and youth advocate, really advocating for proceeding in April 1st. But that was really the only advocate and for that position. So what really kind of helped me make my decision on what to do was testimony.
Yeah, one quick, 2 quick questions. I'm sure we'll hear from the Defender General's office. Do you recall what their position was?
Yeah, I was just about to mention that was kind of the deciding point for me. Martha Paul testified in support of the delay that we have in the bill, and feeling that essentially it's set up to fail if we proceed on April 1st. Certainly you want to hear from him. Amy Davenport was lukewarm about proceeding right away, I think it's fair to say, but you can certainly hear from her. Susanna Davis, I think also was lukewarm. I don't think came right out saying they were delighted with the delay. But
Senator Skills.
I had a similar question because I've had a flood of people saying that they oppose delaying raise the age. So I was curious, and some of those people are people that you've just listed. So I was a little curious about the discrepancy there, but I guess we'll hear from them.
Yeah, no, absolutely. So that's how I interpreted the testimony. I think it was very clear from Martha Paul. The other is just joint justice oversight has been looking at this since more than the past year. As we're getting reports every 2 months, on the progress of what's necessary to successfully implement this. And I think that really, I think fairly clear that DCF is not ready for this, and certainly want to push on that some more, obviously. And it is frustrating. It is frustrating because I think that there's a concern that there was inaction as far as not getting right. And that's certainly, I agree with that frustration, but here, this is where we are. And the testimony was pretty strong that we're not ready. But, having said that, it'll be an interesting vote when we eventually get there, which will be probably tomorrow. And I have some folks who feel that we should be repealing raise the age. And I have folks who are very frustrated that we're not going forward on April 1st. But what this does is it does delay it till the bill would delay going to 19 years to July 1st, 2027. And it would have a reporting requirement, much like the reporting requirement that's already in place with some additional information about red clover. And a report would come in July of next year and December of next year, so that the next biennium, the legislature will be ready to address this. There's one other part that I'll let Eric mention, section 2, when he walks you through this, but that's kind of where we are. It's like I said, quite a bit of testimony. What we really wanted to understand, other than, of course, the basic question of whether the PCH should have an April 1st or to delay or repealed, if there are other red flags that you have with this bill, so that we can at least have it, if there's any kind of obvious thing. Hopefully at this point, since we hardly really don't have that contender any longer, but we'd like, if we have input on the bill, that we should look at before we send it over. That's the whole purpose of being there, because if this is going to go through before raise the age happens, we're hoping that you guys will work on it pretty quickly once crossover happens.
I do appreciate that it's 8 pages. Our ceiling bill will be 40 pages. So,
well, we have probably more time.
Any questions or comments for Representative Bullock?
No, thank you. Well, thank you very much. Now the question I have is whether I go back and repeat any of running by committee upstairs, or should just let it go.
Vice Chair Burdick's not there.
What's that?
Vice Chair Burdick's not there.
He's still running late today.
Might want to get back.
Probably know what happens.
All right, so I'll let Eric tell me if anything else has come up that we need to be aware of. So
Thank you.
all right, thank you.
Morning, everybody. Good morning. Eric Fitzpatrick with the Office of Legislative Counsel, as Representative Levon said, excuse me, here to do the walkthrough after a big picture overview that he gave you of what's at least currently in H2. I think it's indicated it hasn't actually been voted out of committee yet or out by the House. So it's always potential that there could be changes made, additional language added or subtracted, but the way it stands at the moment. Might be helpful before looking at the language just for a moment to refresh everyone's recollection about the big picture that sort of underlies all these juvenile proceeding offenses that are dealt with substantively in the bill. And that's sort of what you're talking about here is when a young person commits an offense that would be criminal. They were an adult and would be brought in the criminal division. Under some circumstances, it is not brought as an adult offense in the criminal division. It's brought as a juvenile offense in the family division. And whether it ends up in one place or the other, criminal court or the family court, depends on 2 factors. What type of offense is it? And how old was the kid? Right? Those are the 2 things that are your sort of bold factors that are coming into play is that determine where this proceeding gets filed and where it ends up. So first factor first, which is what type of offense it is. You may remember, I'm sure, the phrase Big 12 offense is familiar to everybody. Until last year, there was this group of offenses that were referred to as the Big 12 that were determined by the legislature many years ago as a serious group of offenses where if a child committed that one offense in that group, depending on the age, the case would start in the criminal division. So age 14 and up, for example, child commits a homicide or a sexual assault or one of the other offenses that are on that list, even though the child is under 18, case starts in the criminal division. Was that way. It was called the Big 12 until last year. Last year, and as 58, as Representative Belong mentioned, Act 125, you change that number, so it's now referred to as the Big 14. And even though there's a couple of wrinkles to that, but what the legislature did was from the Big 12, it subtracted one, which was burglary into an occupied dwelling. I think it brought it down to 11, but then added 3, and that's how you end up with 14. But the 3 additions, the age range is slightly different for those 3. Those 3 additions were aggravated stalking, drug trafficking, and use of a firearm while committing felony. So those are the 3 that got added. However, those 3 were added only for age 16 and up. So 14 and 15-year-old, for example, who for all the other 11 offenses, if a 14 or 15-year-old commits one of those 11 offenses, starts in the criminal division. But 14 or 15-year-old commits one of the 3 that I just indicated, that still starts in the family division. Subject to, which we don't get into right now, but there's also proceedings that allow for transfer between the divisions, depending on the effect of the branch. But so what I want you to have just for
Eric,
yeah.
sorry,
Sorry,
please have a question. Sorry.
Yeah, before that, I'm gonna hand out a list of those offenses, just so you can keep it sometimes handy. People say, well, what are those 11? What are those other 3? So there's a list.
So it is actually about H2 in this act of delinquency and what that is, because it's interesting to me that, because my understanding is that an act of delinquency is less serious than one of these big 14.
I think it's certainly, those start in the family division, not the criminal division. I think that does reflect the legislative policy determination about which ones are more serious. That's right.
The acts of delinquency. What's curious to me is that for a big 14 offense, it kicks in at 14. For a delinquency, it kicks in at 12. I'm really curious why we wouldn't raise it to match the big 12 at 14. So that's just a point for me that we would say these more serious ones, there's a discrepancy there that they wouldn't start. Like if we're raising the floor from 10, why wouldn't we raise it to 14?
Discrepancy and where the case originates.
Just the age, like we've said, a 12-year-old can do one of these things. It's going to start in family division, but a 12-year-old commits an act of delinquency, and we're going to
For entities or it's something else.
now I'm looking at a bill where we're raising the floor for an act of delinquency from 10 to 12. And I think that if we're admitting that 14 is actually the age where a more serious crime, then why wouldn't we raise this to 14?
I think the distinction in terms of treatment, which maybe you're getting at anyway, is that 12 and 13-year-olds, for example, commits an offense that's not on the list, starts in the family division. So but they can be transferred to the criminal division.
Right.
So there's still a possibility that they would end up in the criminal division being transferred.
And so what I'm like, we've said that below 14 is too young. Like there's a discrepancy there for me in terms of raising the floor. I just wanted to flag that. Yes. I mean, as you know, I should get rid of the big 14 entirely, but that just was a flag for me. Thank you.
Please.
Yes. So with that as background, as Senator Bachowski was kind of segueing us into, so what is the age range? We were just talking about the types of offenses that go into where it is that a child ends up with, whether the family division or the criminal division. Then the age range is also a factor. So in other words, what is the range under current law that a young person who commits an offense that's not a big 14, because remember the big 14, we've said, all right, those start in the criminal, right? What if it's not? What if it's everything else? Well, those start in the family. And that range that the family division has jurisdiction over a child is age 10 to 18, right? So if a young person commits one of these, either a felony that's not on that big 14 list or some other misdemeanor or anything else, basically, then that proceeding starts in the family division. It's a juvenile. And it makes a big difference because remember that family division proceedings are confidential. There are significant adverse consequences that happen to a criminal division proceeding that don't happen to a family division proceeding. Family division proceeding has oversight by the DCF, so that caseworker, DCF, the case plan doesn't happen in the criminal division where someone is supervised by the Department of Correction. So it makes a difference where the child is has the case brought against. So as I said, the age range currently in the family division starts at age 10. In other words, that's a floor. So if a child commits, say, shoplifting at age 10, or some other offense that's not in that big 14 list, they are subject to a juvenile proceeding in the family division, age 10, age 11, age 12, age 13, all the way up through age 18. Now, until 2020, the maximum age was 17. All right. But that's when raised age started. 2018 was when the bill first passed. But it used to be that the maximum age was 17. Now, in other words, your 18th birthday. So below your 18th birthday, and so the range was age 10 to 17. You commit one of these non-big 12 at the time, big 14 now offenses, you could have a juvenile proceeding brought against you in the family division. The proposal that you have in section 1 is to raise that floor age from 10 to 12. So right now, let's say you were age 9, right? You're below the minimum age 10 that's in current law. You commit shoplifting at age 9. Well, you cannot have a juvenile proceeding brought against you because that's outside the range of the family division's jurisdiction. Now, that doesn't mean the fact that a child committed an offense that would otherwise be unlawful is necessarily not going to come up in any proceeding whatsoever. It could come up, for example, in a CHINS proceeding, a proceeding where DCF is seeking to perhaps terminate parental rights or to come up with a case plan for a child when it seems like there's a CHINS situation where they're either beyond their control of their parents or whatever it may be. It's not a juvenile type proceeding, but it's another proceeding in which the fact of their conduct could be relevant. They're not going to be subject to DCF supervision in a juvenile proceeding. That's not a possibility because they're below age 10. Does that make sense? Proposal is to bump that age 10 up to age 12. That's what you see in section 1. So that age 10 and 11-year-olds who now
Just a
would be
quick
offended,
question, do you know the history behind what Chair Lalonde or whomever was Y12?
No, I think that you mean as opposed to why pick that number kind of thing?
Yeah.
Yeah. I think it was just a policy determination as to at what age is it appropriate, given a child's capacity and brain development, that sort of thing. What's an age that made sense for the child to be subject to juvenile type proceeding?
Senator Wilson.
And did the committee hear from child development experts?
I wasn't there for all the testimony, so I'm not certain.
Okay.
But it's sort of a good question to ask either the chair or someone else who might have their list of witnesses. Yeah. So that's piece 1 that you see on page 1. Second piece, the structural language on 16. So as I said, right, that generally speaking, the floor under current law is age 10. So if someone under age 10 can't be charged with a juvenile proceeding, right? There is one significant exception to that, and that is murder. Murder is the one, you see, that was the proposal to strike through line 16 through 19. Specifically carves out murder. It says an individual left to have committed an act before attaining 10 that would be murder. That child could be subject to a juvenile proceeding. So the proposal is to strike the one exception, have the law be consistent. Below age, so it's going to be age 12. The proposal is age 12. So it bumps it up to age 12 generally and gets rid of the carve out for murder. So consistent across the board would be under age 12, not subject to juvenile proceedings regardless of the offense. 12 and above, you can be subject to juvenile proceedings.
So what happens to 11-year-old that commits a murder?
I think again, it's the conduct could be brought into play if say the child were subject to a termination of parental rights proceeding, or the state was planning to seek custody for the child for various reasons. Like I said, maybe they were beyond the control of the parents or whatever it might be. That conduct, a murder, could be relevant and brought into play when the state bring a termination of parental rights proceeding, for example. But it would not be subject to, could be the basis of a juvenile proceeding.
I don't know if this has ever happened. But...
Not in the last 25 years, it hasn't. I just Googled it.
Oh, really?
I don't know if it's happened before that, but for the years 2000 to the present, no child under the age of 12 has been charged with the crime of murder. But I don't know how they picked those numbers. I don't know if maybe one happened in 1999. I was also.
Yeah.
So, over on page 2, this is the second piece of jurisdiction. Remember I was saying, all right, well, generally speaking, the family division has jurisdiction over the child who's committed one of these delinquent offenses from under current law, age 10 to 18. Proposal here is age 12 to 18. However, there's also a provision that allows the family division to extend jurisdiction under certain circumstances. And the reason for that, generally speaking, is like if you're, for example, if you have a 16, 17, 18-year-old who's brought in on a juvenile charge, and if the child ages out at age 18, which is the way it generally works, generally speaking, you age out of family division jurisdiction at age 18. Well, that doesn't give DCF much time to have a case plan and try and work on whatever rehabilitation treatment that they might want to do with respect to the child. So current law provides the ability. You'll see this is line 6 through 11. So the family division can extend jurisdiction. Okay, so for example, current law, you see the proposal change, but line 8. So they can extend the division starting on line 7 until 6 months beyond the child's 19th birthday if the child was 16 or 17 years old when they committed the offense. So you think about the way that works. So you have the child commits the offense when they're 16 or 17, ordinarily at their 18th birthday, or when they, after their 19th birthday, because in this case, since raise age step 1 went into effect. But at that time, they age out of jurisdiction. So this allows the court to say, oh, all right, we're going to, depending on the circumstances, extend jurisdiction for 6 months beyond the birthday if DCF thinks that it could be helpful in the situation. So that's current law. Proposal is to bump that out by a year in each case. So if the child commits the offense while they're 16 or 17 years old, then jurisdiction can be extended to their 20th birthday. And if they committed when they're 18, this is line 10, jurisdiction can be extended to their 21st birthday. So this basically gives DCF more time to have a treatment in those situations if the child admits the offense when they're at an older age.
Does it take 3 years?
Or
Well, they did it prior to their 18th birthday, and now this is pushing it out to their 21st birthday and keeping it before. Does it take 3 years to do this process?
I think it's probably case specific, but that's a good question for DCF. They testified quite a bit upstairs. I think you guys will probably hear from them too. They have a lot of experience with those actual kinds of questions. So what is involved in the treatment and the components of it, how long it takes, that sort of thing. So that's the end of that first topic, which is the family division jurisdiction. Now we're moving on to the raise the age topic, which I think the committee has a sense of from Representative Lalonde, sort of what the proposal is here. Remember that the original raise the age legislation was passed 2018, so quite a number of years ago now. And when it was passed in 2018, there were 2 steps to the implementation of raise the age. At that time, family division jurisdiction over a young person who committed one of those non-Big 12 offenses, only went up through the 18th birthday, so through age 17. So step one was to add 18-year-olds to that. So 18-year-olds would go into the family division if they committed one of those non-Big 12 offenses. That went into effect in 2020. Right? So the 18-year-olds are in there now. That's why, for example, on page 2, line 10, where we were just looking at, so they can extend the jurisdiction if the child was 18 years of age when they committed the offense. Well, that had to be newly added because, back then, if they were 18, that would have been a criminal offense. The criminal division would have been in the family division at all. Now it is, and that was step one, went into effect roughly 5 years ago now, 2020. And the original proposal had this step two, which was 19-year-olds going into the family division for those non-big 14 offenses, would have gone into effect in 2022. That was the original proposal. And it's been extended several times for a variety of reasons. There was a COVID pandemic was involved, the PCF wasn't prepared, and nor were any of the other parties. And there were a couple of other times that the legislature has extended it. And the most recent extension passed last year is slated to go into effect, as Representative Long was saying, April 1st, 2025, this year. So it's only, in the neighborhood of 6 weeks away, I think, roughly. So that's the way the law sits now. So if the legislature did nothing, did not pass any change to what's slated to go into effect, but on April 1st, raise the age would be implemented, would go into effect. The 19-year-olds who commit those non-big 14 offenses would start in the family division, not the criminal. So if you want to change that, you have to act one way or another. So the proposal here is to act, and to act by delaying it for 2 more years, out to 2027. That's the proposal. And so that's basically what happens in sections 3 and 4 is you repeal the 2025 effective dates. That's sort of technical, but that's what's going on in 3 and 4. Then section 5 through 9, over to the space 3 through 5, that basically is reenacting the raise the age for the 19-year-olds. And what it would be helpful for a moment to turn to the very last page, the effective dates, to see how this works. Page 8, section 11, line 5. So you see, if you look at line 7, that's this, what I just mentioned, the repeal of the April 1st effective date. You'll see line 7, page 8. That goes into effect the day before April 1st. That goes into effect March 31st. That's to keep that April 1st effective date from ever happening. That's going into effect. Then you look at subsection C, the next line down, line 8. Sections 5 through 9 shall take effect on July 1st, 2027. So that takes those other sections I just mentioned, the ones that actually substantively implement the 19-year-olds, say, okay, we're passing it, but it doesn't go into effect until 2027. The first couple of sections I mentioned, the ones about the jurisdiction going from 10 to 12 and 6 months, that goes into effect this year. That's the first line of the effective section. But that gives you a sense of how that works. Proposed. So, last piece, or second to last piece to mention, and this happened last year, actually it had happened over the last couple of years too. When the legislature has put a pause on the implementation of raise the age, at the same time, they put reporting requirements on DCF and the HCA Human Services, basically status review. Say, okay, if we're gonna delay this effective date, then we want to hear how it's going. Yeah. So that's section 10, starts on page 6. It's essentially verbatim, almost exactly the same as the one that passed last year. A couple of differences I'll mention, but you had the same reporting effect as the reporting section has been in effect over the past year. One difference is, I think Representative Long mentioned this, is the report had to come every 2 months. So if you look at page 6, line 2, not that frequent. As before, there's only 2 reports required. You'll see July 1st, 2026 and December 1st, 2026. So there's 2 progress reports required. There's also an addition of the committees they have to report to, lines 5 and 6, Senate Committee on Institutions, because they, from what I understand, are covering corrections issues now.
We have to update the name of, really nitpicky, the name of Senate Committee on Institutions and Digital Services.
Oh, yeah. Sure, yeah, I didn't know that exactly. So what's the name now?
It's
Well, I can track that.
Yeah, it's something.
It's institutions and information technology.
And information technology. Thank you.
They haven't officially updated it. I'm not sure.
Oh, they haven't. Oh, okay.
Oh, it's
I
not,
mean, we voted on it, so it's in the rules.
right.
Yeah.
Like, we have to, because we have to vote on stuff to change committee jurisdiction.
Right.
So it may not be updated like on the internet, but it is, we did vote on it.
Yeah. that's-
Okay, thanks. Yeah, so those are to whom the reports are made. The substantive pieces are essentially the same. There is one addition on page 7, it starts on line 14. It's an additional piece of the report. It's a report that's asking for data on the Red Clover Treatment Facility, which is where some of these now receive services through ECF. And they're looking for data on that. So like how many youths utilize the facility on a monthly and annual basis, how long they stay there, what are the treatment needs, racial and gender demographic data, and the other data deemed relevant. So that piece was added. Yep. Actually, it did. So that's the end of the walkthrough thus far, although as I mentioned, has not passed out of committee or out of the House yet, so so it's possible that there could be changes made before you folks can.
Yeah. Committee, any questions on this tentative?
You might just want to look at the name, because in our rules, it actually just says a committee on institutions
So we
and
passed a
expanded.
resolution to expand their scope and change their name. In that resolution, there was also a move of number of committee members in. So we took government operations back down to 5 and made Ed, there was a few things, but there was a resolution that we voted on in the first week.
Would have thought this would be the big spot. There, this bill.
Well, maybe that you want to, you could, but just sort of hold on to that issue and make the change
Yes.
when it comes down here.
Yeah.
For sure.
I don't know that.
Sorry. Mr. Chair.
No, all good. All right, great. Well, thank you for the walkthrough.